Welcome to today's program titled Cultural Flashpoints, Litigation and Investigations, Strategies for Employers. At this time, all participants are in a listen-only mode. For those of you who are logged in to the live web presentation, you are encouraged to submit questions throughout the conference by typing them into the Q&A box on the right-hand side of your screen. For those interested in obtaining CLE credit for this webinar, later in the presentation, we will read the CLE attendance verification code. Please write this code down, as it will not be reread, and it is required on the CLE credit request form. During the program, you will see a slide with a QR code that you may scan to access and submit your request for CLE credit. You can also find a link to the form in the connection details email you received this morning. Copies of the webinar recording and materials will be distributed to all attendees within a day or two following the webinar. On the next slide, you will see a legal disclaimer. This presentation has been prepared by Seyfarth Shaw LLP for informational purposes only. The material discussed during this webinar should not be construed as legal advice or a legal opinion on any specific facts or circumstances. The content is intended for general information purposes only, and you are urged to consult a lawyer concerning your own situation and any specific legal questions you may have. At this time, I would like to turn it over to our first speaker for today's program, Sam Schwartz-Fenwick. Sam, please go ahead.
Thanks, Kate. Happy summer and happy Tuesday. I hope everyone is thriving in the 100+ heat that's blanketing the country right now. I'm very thankful for air conditioning. And as Kate mentioned, my name is Sam Schwartz-Fenwick. I'm a partner in Chicago, and relevant to today, I'm one of the co-leads of our Cultural Flashpoints Task Force, along with my friend and colleague, Don Soloway, who also joins me today. We're also joined by two Flashpoint investigation powerhouses, Anne-Marie Zelatel from our New York office and Sarah Affel from Boston. So I'm really excited for you to hear what we all have to say today as we talk about the wild world of Flashpoint litigations and investigations. Kate, if we could go to the next slide. So a little preview of today, we're going to go over some of the hot trends we're seeing in Flashpoints in 2025, and then go into more detail on what makes Flashpoints litigations and investigations different and why they need to be handled with more care and precision than a typical employment case. And through all of this, we're going to be weaving together a hypothetical so you can get more of a practical view of how this works in practice. Let's go on to the next slide. So just a reminder, we say this at the beginning of all of our Flashpoint webinars, but you can't say it enough. What we're talking about today are, first of all, they're only examples. We're not presenting the views of any of the speakers. We're just trying to tell you different ways clients think about it. And, you know, we 100% view our jobs as being neutral legal advisors and business partners who help meet our clients' goals. So with that in mind, let's dig in and skip ahead 2 slides, Kate, to what do we mean by flashpoints. So this is a summary of what we've seen in the Flashpoint space in the past 3 years. Some of these issues remain germane, but some of them have pivoted. For instance, we don't see cases being filed challenging COVID mandates because those are over. But we do see now cases and claims regarding religious exemptions from measles. So it's a way that COVID created space for this new type of action. And now as new diseases emerge, people are using the same playbook. We're continuing to see a lot of litigation in the DEI space. We're seeing claims of discrimination for requiring people to attend DEI trainings. We're also seeing claims increasing claims by members of majority groups, be they Christian white men, arguing that they've been discriminated against in this DEI world, or woke world. They'll use a lot of hyperbole in their actions. We're continuing to see a lot of strife in workplaces as LGBT inclusion is bouncing up against strong, closely held religious beliefs of both coworkers and employees. That's continuing battles over recognizing someone's name and pronouns, as well as access to bathrooms. This is, of course, made a lot more complicated by the executive orders that have been coming out recently. We've also seen a renewed emphasis on men needing to be men, and that the workplace has gone too soft and become too feminine. There's a real impact from the manosphere in the blog culture that we've seen a lot of executives lean into more of a masculine energy in the workplace, which is, of course, creating a lot of flashpoint issues. Let's go to the next slide, and let me turn it over to Dawn.
Thanks, Sam. So this is what we mean by cultural flashpoints litigation. We really mean litigation that touches on the sensitive and polarizing issues that Sam just reviewed on the last slide. And so flashpoints litigation will touch on protected classes like race, gender identity, sexual orientation, religion. But there's another element to it, because of course, those protected classes are a feature of really any employment litigation. What makes flashpoints litigation different is that the allegations themselves, the allegations, the complaint, and the defenses for the employer also touch on some sort of polarizing, divisive, political issue. And so as we'll talk about in more detail, that means that those cases have a higher risk profile, both on liability and on damages, and also pose a different kind of risk beyond the legal risk to the employer's reputation and to the reputation of individual defendants or managers, witnesses who may be part of the litigation. Next slide, please. And so our Flashpoints Task Force is tracking carefully these cases as they're being filed around the country, and we're defending many of them. And what we see is that the cases are really nationwide, and this gives you this map gives you a flavor of kind of where the numbers are. But these are cases that include conflicts over DEI, mandatory vaccination policies, which are not being filed anymore, but are still actively in litigation. Social movements like Me Too or Black Lives Matter, global conflicts, including the Israel-Hamas war, and tensions between religious rights and LGBTQ or gender identity. Next slide. And you'll see here that these cases are really being filed in every industry. So on the bar graph, education, higher ed field is, of course, impacted in a very substantial way, as we all know from reading the headlines, as is the government itself. And then the third most likely to be hit with these cases is nonprofits. But then you'll see that really every industry is affected by Flashpoints litigation, and that's a trend that we continue to see as the case numbers rise. Next slide. So as Sam said, we're going to introduce a hypothetical for today's conversation that we'll speak about periodically throughout the presentation to try to kind of give you a sense of how this plays out, when we're litigating these cases. So in our hypo, the employer is a large energy company, and there is a white male manager who is denied a promotion. So he's an individual contributor right now, but he aspires to a managerial role and was passed over for promotion. And so he brings a complaint alleging reverse discrimination and claims that he was denied the promotion because of his race, his gender, and his religion, which he identifies as Christian. He claims that the company's DEI policies have disadvantaged him, and that's why he has been passed over. And meanwhile, other employees have been writing letters to management complaining that the company has abandoned its commitment to DEI. And so this is a fact pattern that we see kind of over and over in our counseling and litigation, and that's very much, I think, front and center in the Flashpoints litigation space. So we'll talk about this more as we kind of go through today's presentation. Okay, next slide. And so we want to start by talking about how is Flashpoints litigation different from ordinary employment litigation. And the first way in which it's different, we'll see on the next slide, is that it raises novel legal issues. And so, I think whereas, many single plaintiff or class action cases will kind of tread on familiar standards under Title VII and state analogs, Flashpoints litigation tends to raise novel legal issues because it presents kind of new fact patterns, and therefore the case law is very much evolving. So as an example, the litigation around mandatory COVID vaccination policies, on one hand, those are brought under Title VII a few years ago, and the law about religious accommodation and religious discrimination is longstanding. EEOC guidance is longstanding. But the way in which those cases arose raised issues of first impression. What happens when you copy your religious exemption request from the internet? How do you think about sincere religious conflict when an issue is so politicized? And then, of course, unique questions about undue hardship in the face of a global pandemic. And so we see that, throughout all different kinds of Flashpoints litigation, that the case law is still kind of catching up. And so it requires a certain flexibility and kind of nimbleness in the face of a very evolving legal landscape. Next slide, please. Flashpoints litigation also involves passionate and diverse viewpoints. We all know that employment litigation tends to be a very personal area of the law, where people feel very strongly about their feeling that they have been discriminated or retaliated against, and being accused of being someone who is engaged in discrimination or retaliation. But what we see is that in Flashpoints litigation, it's really at like a whole other level. And what's interesting is that these are hot button issues for everyone, right? For the parties, for the attorneys, for the human resources personnel, for the witnesses, and then, of course, on the other side of it, for the agency investigators, for the agencies themselves, for jurors, for arbitrators, for judges. And so every single person who touches these cases brings their own bias and perspective on issues that are sort of deeply personal and deeply polarizing. And that just creates an environment that is much trickier to navigate than an ordinary employment case. Next slide. Flashpoints litigation also carries an increased risk for explosive verdicts. And this is a trend that we've been following now for years, a trend toward explosive verdicts in the employment space in particular. And Flashpoints litigation is really a perfect environment for the risk of an explosive verdict, because jurors come to court already kind of with strong opinions about these topics, and they're already steeped in kind of anti-institutional and anti-corporate sentiment, and kind of arrive to court ready to unleash all of that on whatever case is before them. And so when you add a flashpoint around religion or gender identity, race, Middle East conflicts, when you add that to the mix, you really have a kind of perfect storm environment for a runaway verdict. And on the next slide, I think Sam will talk about non-traditional plaintiffs' counsel.
Thanks, Don. So something that we've seen in the Flashpoints space is that a lot of the folks who are bringing this. While, an employee will bring the case, they're often backed by um, an advocacy organization. There's a number of these advocacy organizations. They're well-funded and they're motivated not by settling a specific case or getting a payday for a specific client. They really want to change the law, which means that they're, when these cases are filed, they're very professional in terms of the arguments they're making. This is not, your pro se plaintiff's case. And even pre-litigation, you're getting a 10-page letter as to why you have violated the law with all kinds of citations to the Constitution and various statutes. And you see that play out incredibly aggressively in litigation. And so the sooner you're prepared on the back end to tackle that level of an adversary, the more well off you'll be. Given that they're your typical employee plaintiff is also less likely to want to be public about their story. That's not the case in Flashpoints litigation. You have plaintiffs and plaintiffs' lawyers who, it's kind of like you think about the movie Chicago and the way those two defendants in that case just love the public gaze. That's similar to what we're seeing in a lot of Flashpoints litigation and really trying to try these cases in the court of public opinion. Let's go to the next slide. And so one impact of that is there's a much higher risk of reputational harm. You have information going straight to the media. You have lawyers being on talk shows. You have them leaking information or allegations to talk shows so that you can be on, the top story on Fox News, things like that. And you often only get your 30 seconds of fame when that news drops. So it doesn't matter what the facts end up being. That reputational harm can have been caused. So something that's unique about Flashpoints is really from the onset of the litigation, you need a PR strategy. And so you're nimble and able to respond in real time to a lot of this nonsense and negative, kind of the negative noise cycle that's targeting you. It's also important to realize that this reputational harm might not only come from outside, it often comes from inside as your workplace gets really roiled by these allegations and you start seeing a real productivity impact on this, which means that you need to be partnering with employee relations, labor relations, and HR to have an internal strategy as well as a media strategy so that people understand what your company values are, regardless of what's being alleged in a lawsuit. Let's go to the next slide. So yeah, I mean, it's not only the business that's going to face potentially mudslinging. These complaints name names and they list first and last names. They go through and really present facts that tarnish the reputations of leaders in a company. This is not a situation where you can prevent people from testifying if they're deposed or on trial. But what you can do is try to mitigate risk by really doing thorough preparation and having a wide array of individuals in the room when you're doing the prepping of witnesses so they understand how their testimony not only will play in a court of law, which obviously is critical, but also if you say something in a deposition and it's then reported to the press, how will it land in the press? And what are different ways to say the same message? So you want to do a lot of role playing to make sure that you're getting your message across so that it plays well in a variety of audiences. Let's go to the next slide. Okay, so let's go back to our hypothetical, which again is the aggrieved white male who feels like he's the victim of reverse discrimination because he didn't receive a promotion. And in his view, it's because of woke gone wild. So when you're presented with this lawsuit, it's likely that you already will be well aware that it's going to be coming. You likely will have gone through a very heated investigation stage with this individual. You likely will have had to deal with threats from their lawyer that if you don't settle for an egregiously high dollar value, which they know you won't accept, they're going to go to the press and file a lawsuit. So often when the lawsuit is filed, immediately, like that same day, there will be articles in the newspaper or on TV really talking about this and talking about it as if all these allegations are fact. Now, typical practice among corporations is not to comment in litigation. That might make sense in these cases too, but you want to think ahead of time before a lawsuit is filed what your strategy is going to be. So to the extent you do want to make a comment, it's mapped out what you're going to say, so you're able to get it out in real time. Again, many clients will choose it's never a good idea to make a comment, and that's valid too, but you want that to be a proactive decision, not reactive, because if it's reactive, you probably won't have enough time to make that decision. You also want to think about how every statement you make at every stage of litigation needs to play for a number of audiences. It's going to need to play before the agency, it's going to need to play before multiple courts of law, and it's going to need to play in the court of public opinion. You need to weigh those different audiences and think about how you want to keep your message the same throughout. And you want to remember at all times that your finder of fact, in this case, judge or jury, is just a person, and you need to lower the stakes for that person. You do not want them to feel like their job is to be a moral arbiter. You want them to feel like their job is to decide a boring question of employment law, which is, did you follow your policies? You really need to lower the stakes and keep reminding people the stakes are low here. You're not, our job is not to play God or a higher power and decide who's right or who's wrong in that level. So the more you can lower the stakes, the better. Okay, let's go to the next slide because I know we're running a little long. One more ahead. Okay, so this is a fabulous graphic. I just want to say I had nothing to do with the graphic, so please thank the other presenters for having creative bones in their body, which I was born without. So Flashpoint starts pre-litigation. What does that mean? It means we live in a polarized world where people no longer know how to talk to each other or how to listen to each other. It means that people are really ready and eager to cancel each other and to not let things slide. It's a very aggressive culture that we live in. And as companies, we need to take proactive and consistent measures to lower the temperature. There are policy angles to that in terms of what type of expression you allow in the workplace, but there's also a real place for training. Remembering what our goals are at work and why we're at work. It can seem simple, but reminding people that you're at work to work, not to be, some type of social rights vigilante, can be an important reminder. And obviously, you need to massage your language. You never want to say it the way I just said it. You want to remind people that, their job is to work, and we need to accept people's differences so we can get the job done. That's a better way to say it, but you get the drift. But that's an important way to try to lower the temperature. Let's go to the next slide. Also keep in mind that your Flashpoints defense starts on day one. We already talked about some of this with your PR response, but it also means in every thing you file with the court, in every PR piece that comes out, you need to be tempered in your messaging. There are going to be a lot of landmines that plaintiffs set for you that are traps they want you to walk into so they can say, look at what this employer just said. You don't want to take the bait. You again want to keep this as boring and neutral as possible. We're not taking a position on X, Y, and Z cultural issue. We more looked at the facts here, looked at our policies, looked at the law, and made a decision based on that, just as we would have if it was, your run-of-the-mill employment case. That's a critical issue to prep witnesses for in depositions in a trial, because it's very hard when someone's attacking your integrity and trying to get under your skin. So you really need to view this in a big picture lens from day one. That's the only way to win the battle and succeed. Let's go to the next slide. Think long and broad. And I'll just touch on this for a second. This is really just remembering big picture. You don't win the war in one day. There's a lot of stages, and you need to perform at each and every stage by keeping big picture, having a mapped out strategy, and keeping things neutral and calm. And with that, let me turn it back to Dawn.
Thanks, Sam. Next slide, please. So this is a quote from one of the associates on our Flashpoints team who always says, keep it boring. And I think Sam alluded to this a little bit. A key rule of Flashpoints litigation is not to litigate the flashpoint itself, right? So a case that touches on issues of gender identity or conflicts in the Middle East, the litigation, the employment litigation is not about that conflict. You're not going to solve that conflict in the litigation. And really the point of the litigation is, did the employer follow its policies? Did it make decisions for legitimate business reasons or for some sort of discriminatory or retaliatory reason? And that sounds simpler than it is to sort of do in real life, because there's a temptation, I think, in the pleadings or in depositions to kind of descend into the flashpoint itself. And it takes real discipline and strategic vision to kind of align on a strategy from the outset where you're not going to get into the polarizing issue. Next slide. Staying nimble is key in Flashpoints litigation because, as I talked about before, the case law is evolving on these issues. So let's take, for example, DEI, right, which is a big topic right now, the subject of many executive orders. That landscape is evolving extremely, extremely quickly. And none of us knows exactly where the law is going to land on those issues. And so part of litigating a case that touches on those issues is to stay flexible, to preserve all possible arguments for appeal, and to be thinking about, how is this argument going to work if the law goes this way versus that way. And so again, it's really a kind of different frame of mind than in an ordinary employment case where you're dealing with static, law involving Title VII or state law analogs. And it's also an area where there are a lot of complex intersecting laws. So there's the federal anti-discrimination laws, there's the state law analogs, there's the National Labor Relations Act, which applies even in a non-unionized environment. And then there are a lot of state laws that touch on things like off-duty conduct and political expression. And so when you're thinking about defending one of these cases, you're really having to be looking at that whole broad intersecting framework, even as it's evolving, kind of the sand is shifting under your feet. Next slide. This is a key in Flashpoints litigation, is really investing in a totally different way in deposition preparation. Witnesses are nervous at depositions on the best day. And when they're also having to endure questions that touch on some of the most polarizing and divisive topics, it is really kind of next level in terms of stress. And so investing in preparation to get the witness comfortable, to do practice examinations, including the very kind of intense cross-examination that witness is likely to face in the deposition. And so that's really an area where an investment in that prep is going to go a long way. Next slide. It's also really critical in these cases to pay attention to cultural literacy. And we use these images to illustrate the point because we all know that the terms Black Lives Matter, All Lives Matter, Blue Lives Matter have very, very different meanings and are all in their own ways, something that has been politicized. And it's essential for the team that is working on the case, that's defending the case, to have a deep mooring in cultural literacy, to understand the terms that are being used, to not sort of accidentally step on a landmine in a pleading. And we've seen examples where even the language used by an employer in a responsive pleading becomes itself the subject of a news story. Because it is so easy to step in those landmines. And so it's really critical to have a team that is very aware of the terms that are being used and trying to kind of use the most neutral, keep it boring language in the defense of the matter. Next slide. And then it's also really crucial to invest in jury studies and jury selection, and particularly if the budget allows, because we've seen that mock juries and focus groups can really be an incredibly useful tool to test narratives, to learn what additional questions the mock jurors wish that had been answered. And at trial, the litigation team is going to have to be really strategic about how to ask potential jurors about bias, about flashpoints, without alienating those jurors before the trial even starts. And so those are some of the key considerations that we think about when we're defending Flashpoints litigation. And now I'm going to turn it over to Anne-Marie and Sarah to talk about Flashpoints investigations on the next slide.
Thank you very much, Dawn. So like other workplace complaints, Flashpoints complaints must be promptly investigated. And Flashpoints investigations tend to raise distinct issues and involve increased risk when compared to other more routine investigations. And so I'm now going to touch on some of those distinct issues and the ensuing risk. Next slide, please. So first, Flashpoints investigations are more likely to be followed by protracted, high stakes, and public litigation. And in fact, in the litigation, the investigation itself may be under scrutiny. And therefore, the investigation tends to be a higher stakes investigation, again, when compared to an ordinary workplace investigation. Also, Flashpoints investigations, because of the Flashpoint complaint, are more likely to be public. And because they're public, you're more likely to face scrutiny from both employees as well as external scrutiny from vendors or the public or customers. And at the same time, you're more likely to receive internal and external pressure to make the right decision, or what various constituencies view as the right decision. Flashpoints investigations, because of the issues or the inherent nature of the complaints, more likely to, you're confronting very strong emotions on all sides. And as a result, the investigation, if you have an inexperienced investigator, it could jeopardize the impartiality of the investigation. It also can jeopardize the productive collaborative work environment, because you have employees who may be on opposite sides of an issue and they are expected to work collaboratively and cooperatively together. Next slide, please. So also Flashpoints investigations are more likely to implicate not only the reputation of the company, but also the reputations of individual executives, human resources employees, managers, and employees. For example, you could have, a complaint that stems from an executive making controversial comments at a town hall, an employee town hall. And these comments are publicized, and as a result, the executive is concerned, not only about whether he or she followed company policy, but also about how the investigation and any ensuing litigation will impact his or her reputation. Also, investigations into Flashpoints complaints can and often do result in much more business disruption than your routine workplace investigation. For example, we've seen employee walkouts, protests, sit-ins, action of that nature, and this can be obviously extremely disruptive. We've also seen boycott campaigns from customers and clients. Other issues that tend to arise in Flashpoints investigations are, a heightened concern about personal exposure, as well as personal safety. For example, in one investigation, an HR employee received, online threats because the complaint and the investigation itself were public. And so, there's a lot of chatter on social media. So concerns about doxing and threats and other, personal safety concerns tend to arise. Next slide. Now going to turn it over to Sarah to talk about the company's core values and how those values, influence the handling or the conducting of the investigation.
Yeah, so thank you, Anne-Marie. And with Anne-Marie's introduction on how these investigations are different, it does then ask, what do we need to do to investigate in Flashpoint matters? And Anne-Marie and I are going to go through a handful of slides here talking about some of the things that need to be considered, how to select an investigator, for example. But here to start with, you need to keep your work around these investigations honed or moored to the company's core values. And I say this because all investigations, no matter what the issue, you need to be following the applicable laws, regulations, and written company policies. Those are a given, and we'll spend some more time on those in the next couple of slides. But those are critical because they are defining the standard to which your employees need to be held. And you have set those standards with the law as a minimum and perhaps higher for the employees at your own company and your expectations for their conduct. But you have set those standards based on the company's value. And when we look at a Flashpoint issue, the first thing we find ourselves often telling clients in counseling is to avoid the act first, ask questions later approach. These can be highly emotional issues, and to have everyone involved in decision making ensure that they're not getting caught up in the moment and rushing to judgment, that they're instead recentering in the company's values, which should be reflected in your policies and procedures. Part of that can also mean taking an appropriate interim action, which may mean placing someone on a paid administrative leave, moving people's shifts around, moving work locations to allow for an environment that is productive and safe for those involved, but also the amount of time you need to think to make the right decision. Here, one of the things that's unique to Flashpoints is that we are finding ourselves in a point of particular flux with the law and flux with the politics surrounding the law. Whereas for years, we may have spoken about Title VII as a fairly static law and standard, and it was just about applying the facts to that. That isn't exactly the case at the moment. But we, as investigators, are not litigating the political issue and making sure we look at this. Your values is that your employees are held to the company's standard. You are not litigating the issue of a political question or of the state of civil rights law in the workplace. That is not the question of an investigation. The question of an investigation is, are you properly holding your employees to the standard you have set for them? And so when I think about a workplace investigation in general, but particularly a Flashpoint investigation, what I like to think is that durability is really going to be the watchword for your investigation. You need to stay moored to these core values as they are reflected in your policies and the standards in which you hold your community, because you're going to rely on this investigation perhaps for years to come. Your goal is to find facts based on the credible evidence. Doesn't matter what happens in the law now or in the future. The facts are going to be the facts to the best of your ability based on the available credible evidence. So that has to be where we find our values in identifying as best as you can what happened. And second, you'll do an investigation now and institute appropriate disciplinary or remedial measures promptly. If this investigation is tested in the courts, that might be years away at best with the way in which many things move. And if there's anything COVID has shown us in the past years, we, judges, juries, all seem to have short memories for difficult times in the past. That's over, and now it's like we've forgotten. And when somebody's asking questions about 2021, what were you so worried about? It's like, well, apparently we've all forgotten what we were worried about then. But your investigation is in this moment. It's not in the future. So you want to stick to those values so that years down the line, somebody looks back at that investigation file and say, this reflects a careful, diligent finding of facts to the best of the ability at the time and reflecting the company's policies and procedures that showed what standard you have chosen to hold your community. And then next slide for Anne-Marie on another core issue for looking at with our investigations.
Thank you very much, Sarah. As Dawn alluded to earlier, the law in the area of flashpoints is in a state of flux, and it's really critical that both the investigator as well as counsel who is advising, providing legal advice on the investigation, be well versed in the applicable law. Even though that law, as Dawn said, is shifting like sand under our feet, it's important to stay abreast and be aware of developments. And of course, we have Title VII and state law equivalents, but then we also have to consider the National Labor Relations Act. And recently, I've had conversations with clients who were quite surprised to learn that the NLRA still applies, even though they do not have any unions. They're a non-unionized workforce. Employees, at least employees who are not supervisors under the NLRA, have the right to engage in protected concerted activity and tend to do so much more frequently than ordinarily when it comes to flashpoints. You also have state political and off-duty conduct laws that protect employees who engage in lawful off-duty conduct. There may be exceptions when that conduct infiltrates the workplace and causes a negative impact on the workplace. But it's important that the investigator be aware of those laws and the exceptions and the scope of the exceptions. Also, we have President Trump's recent executive orders that touch on diversity, religion, and gender identity, as well as EEOC guidance that seems to be coming out by the week. So when you look at this complex web, it is difficult to stay abreast, but it is critical that both the investigator and counsel providing legal advice do so, because the laws will impact the investigation and the findings. So with that, I will turn it back to Sarah.
So when it comes to your applicable policies, these are going to be most crucial in an investigation because that is what your investigator is following. And when we are an investigator, we're often tasked as step one, you have a summary of what the general facts are, what policies are in play. And when you do that, your investigator should be able to say to the parties involved in investigation, I am applying this particular company policy and why that's the applicable policy. That means having a sort of fluency with your own policies. If you're in-house counsel or if you're an HR professional, knowing what the policies are and keeping them up to date, because those policies need to reflect compliance with the laws that Anne-Marie was just speaking about, but those laws do set a base level. So you need a policy that says you will not discriminate. You may also, as a corporation, have decided to put in place a policy outlining respect in the workplace or professionalism guidelines. Those may all be wrapped up in the same investigation that is responding to a conflict that started between employees around a flashpoint. So being able to see what those policies are, know them, and keep them up to date. We want to see policies that have a sufficient amount of specificity so that your employees understand to what standard they are being held. And that also makes it easier for the investigator to apply the policy. But you also need to write policies to leave an amount of discretion to the company. And when I say that, it's because you don't know what you don't know yet. We cannot anticipate what the next cultural flashpoint issue will be, but what we can say is that we've seen year after year how those flashpoint issues have pushed up at the edge of how policies are written and therefore come into the gray area where you're not sure where they apply. So having written specific language that acknowledges that sometimes something could fall under two policies, that acknowledges the authority of your company to have an investigation, how you're going to run that investigation, and who will take responsibility of it, can then give you the solid ground that an investigator needs to do their work of identifying, and as Dawn had said before, keeping it boring. What happened here? And what happened here, how does that relate to your company policies? You may have a company policy that prohibits a certain level of essentially screaming and yelling in anger. What the people were screaming and yelling about should be immaterial to the application of that policy in many situations. So in the terms of keeping it boring, look at your policies and look at the behavior and consider it in that 360 way. Consider the value in doing your investigation of knowing what your past practices were. Your policies need to develop and change over time, but understanding how they've been applied can help really ground your investigator in having a investigation that stands up over time. If you're going to deviate from past practices or change a policy significantly, keep a record of why. Understand it was maybe the right time and the right choice to make those changes, but keep track of why you're making those changes. Keep the old versions of the policy so that you can have an institutional record and memory of as you've developed them. And in terms of knowing how you have applied the same policy over the years, consider what practices are available within your organization to keep track of past investigations. The person doing the investigation may change over time as personnel changes or as you maybe outsource some investigations, but not others. But being able to have a touch point as time goes on to hone your institutional memory will help you and will really help your investigator as they understand why they're doing what they're doing, why the policy says it is, and how to best apply it consistently with the company's values and practices. And when it's time for a change, to identify that and make the change to apply with the current situations. Next slide, please. One of the last topics to be covering for us around a flashpoint investigation is a core question of how we do this is who the investigator should be. It is critical that a company is identifying and selecting an experienced, knowledgeable, and appropriately trained investigator. In many cases, that can be someone internal. It is often very valuable to have a strong team that is regularly trained to conduct internal investigations internally, that can support one another, and that conduct enough investigations within the company to keep those skills sharp and honed. Whether or not you have the staffing for that and that works for your company, there are still going to be times where it's not going to be the right choice to use one of your internal investigators. And at the beginning of a matter, thinking about when and why that might be, and why maybe you use your internal person and make sure they've got a direct line to in-house counsel and feel very supported, or you choose to use someone external and they should also have the support to make sure they're following your policies. But some of the things that we consider when we talk to clients around whether this is the right case to do internally or externally can involve considering things like, for example, is there a high-ranking individual accused of the misconduct in the policy such that it would be difficult for a member of the company to feel as though they could investigate this case? For example, if an accused individual is their supervisor, or at such a senior level that they essentially are everyone's supervisor. That does not mean that they cannot do the investigation. It's just one factor to think about. Another factor to think about is whether or not the heart of the issue in the Flashpoint investigation is so politically, socially, or internal to your company fraught that it may lead to stress or burnout for your internal team, and that you think that in preserving that staff's long-term with you, that it's right to remove them from a particular investigation. There may also be times where staffing is just insufficient in terms of their current skills or the time available to get the job done as quickly and as well as it needs to be. And last is to think about privilege, which I'm going to toss to Anne-Marie in a second. But in considering this, a question from the chat, and I'm already in my sort of notes for today, is when you're asking whether or not the investigator has the right knowledge, skill, training, capability to do the investigation, that's separate from asking about the investigator's own identities. And you want to keep that in mind. The investigator needs to have these skills. Sometimes this may cause somebody to ask, well, can someone who is the same group? Yes, somebody who is the same group or affiliated here with one of the Flashpoint issues could do an investigation, but you want to make sure the investigator is consistently asking themselves, and your supervisor, or if you're hiring outside counsel to do this, is asking the right question, which is whether or not this person can be neutral in this case. And a good investigator should be asking themselves that all the time. And there may be times where someone says, this isn't the right investigation for me. So that's one of the good examples of, if your internal person says that, to step to someone outside. But that doesn't tie necessarily to the individual protected classes of the investigator themselves. And I'll toss to Anne-Marie to a critical issue on choosing your investigator and just conducting your investigation is considering issues of privilege and cases where there will not be a privilege for the final work product of your investigator.
Thank you very much, Sarah. And because Flashpoints investigations are more likely than routine workplace investigations to be followed by litigation, it's really critical to decide at the outset whether the investigation is going to be handled under privilege. And at the same time, there's no guarantee that even if you decide up front that the investigation will be handled under the privilege, there's no guarantee that the privilege will hold. Also, I think it's more likely in Flashpoints litigation that at some point, even if you conducted the investigation under privilege, you may decide in the litigation that it's in your best interest to waive the privilege in order to defend the company against the allegations in the lawsuit. For example, to show that you conducted a thorough and robust and impartial investigation, and that the investigation found that the allegations did not have merit. So for all of these reasons, a well-documented investigation is key when we're talking about Flashpoints investigations. And what do I mean by well-documented? First, it's important that the investigation report document the scope of the investigation, what was in scope and what was not in scope, and really clearly set forth each of the allegations that was part of the investigation. Also, the report should list all of the individuals who were interviewed. Of course, there's the complaining party as well as the accused, but all of the witnesses with whom the investigator spoke, as well as all of the documents, the policies, notes, journals, other documents that the investigator took into consideration and reviewed as part of the investigation, as well as not just the findings with respect to each allegation, but why the investigator found the way that he or she did with respect to each allegation. And so the way that I do that is, to list the allegation and the finding, and then sort of in a bullet point format, the evidence on which the investigator relied to make that factual finding. And then the witness summaries should also be clear and complete. And with that, I am going to turn it over to Dawn to discuss how we can help.
Thank you, Emery. So let's go to next slide. Next slide, Kate. So if you're wondering if you're in-house counsel or general counsel or HR listening today and wondering what you can do right now to try to tackle some of these issues, we first would suggest that you consider having an internal cultural flashpoints task force where you bring together people from your legal team, your HR team, maybe employee relations or labor relations, PR team, who can help think through flashpoints issues more generally, but including litigation and investigations. It's also really important to create a process to flag flashpoints litigation. So looking, to sort of sensitize your internal team to be aware of cases that come in that have particular connections to polarizing or divisive or political issues that pose unique levels of reputational harm either to the company or to your executives or witnesses. If you're an entity that has a large volume of litigation, it may be about kind of pulling those out of your ordinary process to give them special attention. It's about choosing the right litigation team that's really equipped to handle the many complexities and increased risk exposure that's part of these cases, and making sure that you're getting started on the right foot. That means that, something like a position statement that might seem kind of low stakes in an ordinary employment case is actually an incredibly critical document where you are going to be setting out the company's position. And that position statement is going to follow you through, 5 years of litigation potentially. And so making sure that you have the right team in place and get started on the right foot right from the very beginning. And then on the investigative side, making sure that you're choosing a Flashpoints aware investigator who has the cultural literacy and the training that Sarah was just talking about. And again, maybe taking that case out of the ordinary investigative process if it requires special attention and care. Next slide. And we're here to help. We have a dedicated Cultural Flashpoints task force that was founded in 2023. We've been focused intensely on these issues for years now in a really unique way in the industry, and happy to help with counseling, with litigation, with investigations, either sort of leading the legal advice on an investigation or serving as a third-party investigator. However we can help, we're here for you. Next slide. And I'm going to read the CLE code, which is SS as in Seyfarth Shaw, SS 1672. That's SS 1672. So thank you so much for being here today, for your great questions. We really appreciate you. Have a great day.
Yeah, thank you so much.